13 May 2025, in the matter of Mbenenge and Mbenenge, we are proceeding. Advocate Skippers, is it for the tribunal is the ball in the court of the tribunal?
That is correct, Chair.
The tribunal is this morning giving a ruling on whether or not I repeat, whether or not Mrs. Vetten should come and testify on the aspect that she has been called upon to come and testify. There's been some objection against that on two fronts. Firstly, with regard to whether or not she should be allowed to testify without having timeously filed a summary of her expert evidence. That issue, as far as the tribunal is concerned, has been resolved in the sense that the tribunal has indicated, as it did before, that for that to happen, she needs to have her the summary of her expert evidence delivered and served on the other side timeously so that the other side could have time to have a look at it, and if so advised, decide on whether to call their own expert who might then have the opportunity to look at Mrs. Vetter's evidence and decide on the way forward. That aspect has been resolved in that it has been ruled that the summary will be served in a manner that will allow the respondents to deal with it as I've described. So there won't be any prejudice to the respondent in that. That summary will be served in accordance with the rules and in accordance with the rules of natural justice. That one has been resolved now. One aspect on which there's been some disagreement is whether or not she should be allowed to come and testify at all, whether today or tomorrow or June or whatever. And the parties could not agree on that one, and we are here to give a ruling on that aspect as well. One of the arguments raised by Advocate Sikakane was the issue of relevance of the evidence by the expert and its materiality perhaps to to the matter at hand. But on the other hand, there has been some counter-argument to say that the evidence is relevant and material. So, having considered the matter properly, we are the view that we should rather err on the side of caution, rather allow evidence, even though there is argument about its relevance, allow it nevertheless to be given. We allow it to be given because we are confident that if it is irrelevant, we'll be able to hold accordingly at any time, even at the end of that particular evidence, we will say it is irrelevant and then we will put it aside. Contrast that with a situation where you exclude evidence, which might well be relevant and material. We think that in that case, we would have erred. So like I said, we want to err on the side of caution. Our resolve is that we should allow her to give evidence. And as I've said, if it turns out to be irrelevant, we are competent, I believe, to deal with it, and there will be no prejudice to anybody. For these reasons, we conclude that she should be allowed to testify, subject to the guidance that the tribunal gave some weeks ago, a week ago, and again yesterday, and again this morning. That being said, therefore, the ruling is that she should be allowed to testify. The details of the timetable as to when document or other copies of evidence may be exchanged between the parties is a matter that can be sorted out either in chambers or amongst the parties. We so rule. Thank you.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Chair, I think it has been discussed yesterday, and we can just confirm by the team from the respondent whether or not they are going to continue with other witnesses before this witness is allowed to testify. But they indicated yesterday that they are not going to do that. They want to hear Ms. Vetten's evidence first, but we can just confirm if that is still the position.
Yes, it may well be. I don't know whether this is a matter we should deal with in chambers or we can deal with it now. The advocates, I think we believe that this aspect would better be addressed in chambers, where we would also raise related issues. Because, for example, right now we can't adjourn or postpone the hearings. We'll have to look at other aspects so that when finality is reached for today and we decide that the matter therefore be postponed, we would have sorted out the exact date to which it is to be resolved. So let us adjourn, then go into chambers and look at that aspect. So the matter is for now adjourned and we'll resume later. Thank you.
Thank you, Chair.
Witnesses at this stage, the matter has been postponed to the period 30 June to 11 July 2025. Proceedings are adjourned. Thank you.
Thank you, Chair.